Okay, hello everyone. It's a little bit after the hour, so I want to get started. So good afternoon, ladies and gentlemen. A warm welcome to our webinar, Your Guide to Estate Planning, brought to you by IDB Global Federal Credit Union. Our presenter today is Maria Stamoulis with the law offices of Maria A. Stamoulis, PLLC, located in Washington, D.C. Her practice has encompassed all phases of personal tax planning with concentration in the field of estate and gift tax planning and federal, state, and local taxation of profit and nonprofit entities. She is a frequent speaker on issues involving estate and gift tax planning for foreign nationals. Maria received her Master of Laws in Taxation with distinction from Georgetown University, and she's a member of the District of Columbia, Maryland, and Virginia bars, and is involved in various professional and community organizations. So a warm welcome and thank you for joining us today, Maria.
Well, thank you very much. It's a pleasure to be with all of you, and thank you for joining us. And I hope over the next hour that I will be able to give you an understanding of what estate planning involves and some of the issues that you need to be concerned about. So if we could have the next slide, please. Planning your estate. I'm sure a lot of you have probably spoken with friends or other coworkers and been asked the question, well, have you done your estate planning? And what is estate planning as in general terms? What does it involve when you plan your estate? What are the objectives of estate planning? Estate planning has several different objectives, very important objectives. First and foremost is controlling the manner and the timing for the distribution of your assets. If you pass away, a lot of people assume that their assets will just go to their family, but who among their family members will receive the assets and when will they receive those assets? What if your family members are minors? What if they're young children? They don't have the legal capacity to receive property. So when you do estate planning, you might be able to, you can impact the timing for the distribution of your assets. You might be able to set up trusts for the minor children or make other provisions. One very important aspect of estate planning is avoiding or simplifying the probate process. And we'll be talking about probate and what it involves. But I'm sure a lot of you have heard, oh, you've got to avoid probate. You need to do everything you can to avoid probate. So what is it? How do you simplify it? You can do that through estate planning. Another very important objective is naming the appropriate persons to manage your affairs. When you pass away, someone has to be responsible. Someone has to pay your debts, file any tax returns that are due, make sure that everything is taken care of before the property can be distributed to your beneficiaries. And it might be your spouse or a partner who would be the appropriate person to do that, but it may not be. It may be someone else altogether. And if you do estate planning, you can name the executor of your estate. You can name trustees for your children. You can name a guardian for your children. If your children are under the age of 18 and something happens to you and your spouse, then you need to name a guardian to have custody of the children. You can do that as part of your estate plan. Finally, well, not finally, but minimizing federal and estate taxes. That's a very important aspect of estate planning. And also planning for incapacity. Estate planning primarily deals with the transfer of your assets at death to your beneficiaries. But a very important aspect of estate planning involves planning for what happens prior to your death. What if you are incapacitated? So as part of your estate plan, you also want to plan for incapacity, and there are certain documents that you can use to do that. Okay, so next slide, please. So what are the consequences of doing nothing? What happens if you don't plan your estate? Well, first of all, state law will determine who will receive your property. State law determines who has the right to serve as your executor or personal representative. Those are used interchangeably depending on the state in which you live. If your spouse doesn't survive you, a judge will decide who's going to be appointed the guardian of your minor children and who's going to have control of their property until they become adults. You lose the opportunity to establish trusts for your children. And in the long run, taxes may be higher, estate taxes may be higher. Next slide, please. So What does estate planning involve? At a minimum, everyone should have a last will and testament. That's kind of your most basic estate plan, a last will and testament. It says, in the event of my death, this is who I would like to have my property. You may also have a revocable trust. And a revocable trust is we'll see in a minute, is a document that allows you to avoid probate and kind of helps you to, provides for the distribution of property at death, but may also provide some assistance in the event of incapacity. Another very important document is a healthcare power of attorney or a medical directive, okay? A living will, a general power of attorney. These are your basic estate planning documents. There are other estate planning documents that you can do depending on how complicated your estate is and if you're worried about minimizing estate taxes. But a basic estate plan will contain at least a last will and testament. It may contain a revocable trust. It should have a healthcare power of attorney or a medical directive, a living will, and a general power of attorney. As part of the estate planning process, you also may see about retitling assets, making sure you have the appropriate beneficiary designations for things like your pension and your life insurance. For example, if you have minor children and you've got a life insurance policy, you can't really designate the minor children as beneficiaries of the insurance policy. It's going to cause problems down the road because they don't have the legal capacity to be the beneficiary to receive the insurance proceeds. So a basic estate plan will involve the creation of these basic estate planning documents, and it will also involve making sure that all of your beneficiary designations are appropriate. Okay, next slide, please. So planning for incapacity, let's start there. Before you pass away, let's say you become incapacitated. You need to make arrangements for your medical care and treatment. If you are not able to make medical decisions for yourself, who is going to make those decisions for you? Is it going to be your spouse? Is it going to be your parents? What if they all disagree? That can happen. I don't know if you all remember, but many years ago, probably going on 20 years ago now, we had this case down in Florida. It was the Terry Schiavo case, and we had a wife who had been in a coma for 10 years, and her husband and her parents were fighting as to whether or not she should remain on life support. And the parents were arguing that we know our daughter will recover one day. We want to keep her alive on life support. And the husband was saying, well, we talked about this. We went to an attorney. We saw an attorney. She was going to do a document saying that she didn't want to be kept alive on life support, but she never got around to signing the document. So unless you expressly state your wishes regarding your medical care, it may be up to the courts to ultimately decide what kind of medical care you're going to get, especially if your family doesn't agree. So it's very, very important to have a document, a healthcare power of attorney, a medical directive, in which you set forth all those things and you spell out who should be making those types of decisions for you. If you're not able to speak for yourself, who's going to make those medical decisions for you? And it doesn't just have to be end of life decisions. It could be that you're temporarily incapacitated. You go into a hospital, you have some surgery, and someone needs to pay your bills while you're recuperating, okay? That is financial decision making. So not only making decisions about your medical care, but also making decisions about your finances if you are not in a position to make them yourself. People who are married often say, well, my spouse will do it. And that may be true, or my partner may do it. But certain things your spouse cannot do for you unless they have power of attorney. So next slide, please. When we're talking about medical decision making, you all have probably heard of something called a living will. A living will is nothing more than a statement regarding your wishes pertaining to end of life treatment. So if you are suffering, if you're in a terminal condition, if you're suffering from a coma, what kind of treatment do you want? Do you want to be kept alive on life support? Do you not want life support? Do you want to receive nutrition and hydration? What if you can't take food by mouth, food or water by mouth? Do you want a feeding tube? That's basically what a will is. It's a statement of your wishes regarding life support and other heroic measures if you're near the end of life. That's an important document to have. But in my opinion, a more important document is a healthcare power of attorney or an advanced medical directive. In that document, you actually designate an individual to make those decisions for you. And that individual would also be authorized to make decisions concerning the withdrawal or provision of life support. That's a very important document because it can forestall a fight between family members over medical treatment. Like the Shivo case in Florida, we had the husband and the parents. If she had gotten around to signing that medical power of attorney that her attorney had drafted, if it had been signed, it would have named the husband to make those decisions for her. And he then would have been able to take her off of life support without having to go to court. Okay, so next slide. Um, uh, Medical powers of attorney are also important because they can, you can designate in those documents if you want to be an organ donor, if you want to donate your body, if you want to donate organs, if anything that you want to do, you can spell that out as part of that medical directive. You can always do it on a driver's license. There's a little box you can check if you want to be an organ donor. Some people have very specific instructions as to what they would want done in the event of death. I've had clients who have chosen to donate their body to a medical school or who have made other arrangements. So anatomical gifts is something that you can also address in a medical directive. Okay. Next, please. Okay, so I talked about making medical decisions for you, but I also mentioned that someone needs to be able to make financial decisions for you in the event you're incapacitated. And there are different ways you can do that. Probably the best way to do that is to do what is called a durable general power of attorney. A power of attorney is a document in which you, the principal, authorize another individual, who's often referred to as your agent, to make legal and financial decisions on your behalf. And it's called a durable general power of attorney for a couple of reasons. Durable because it doesn't terminate upon incapacity. Under the common law, if I gave someone power of attorney and then I became incapacitated, the power of attorney was no longer effective. So you want a power of attorney that is durable. It will contain a provision that specifically states that the agent's powers do not terminate upon your disability. So it might say something to the effect like, this power of attorney shall continue even though I'm incapacitated. Or, there are no magic words, but you just want to make it clear that the power of attorney continues beyond your incapacity. It's a general power of attorney because it authorizes your agent to do anything and everything that you could legally do for yourself, to deal with the pension department, to deal with Social Security Administration, to buy and sell real estate, to open and close bank accounts. Anything that you could do legally, sign contracts, anything that you can do yourself, your power of attorney has the ability to do on your behalf. It is a very powerful document. And obviously the person that you give power of attorney to, the person that you name as your agent, you have to trust them. They have to be responsible, and you have to know that they are going to act in your best interests. Otherwise, you don't give that person power of attorney. In many situations, it's husband and wife, they'll give each other power of attorney, and then you might name an adult child or some other family member or a trusted friend to serve as the backup. You can name more than one person to be your agent, but you have to understand that if you name two people to act jointly, it's much harder to get anything done. So if I have co-agents in a power of attorney, every check has to be signed by two people. Every contract has to be signed by two people. Every telephone call to the pension department or the Social Security Administration or wherever, there have to be two people online. So it gets a little more complicated. I mean, you could draft around it. You can say, well, I name both of these individuals to serve as power of attorney, and they can act individually of each other. They can act separately of each other. But then you've solved one problem, but you've perhaps created another, because now you have to worry about whether those two agents are going to act in unison, whether they're going to coordinate their actions. Having said all of that, a power of attorney is a very important document, and I recommend that in addition to a will, everyone have a general power of attorney. If you don't feel comfortable making it an unconditional power of attorney, a power of attorney that's effective immediately, you can condition it upon your incapacity. You can say, for example, this power of attorney will not become effective unless my attending physician certifies that I'm incapacitated and not able to manage my affairs. That prevents the agent from actually taking any action so long as you are capable and able to manage things. But in the event you become incapacitated, that agent could step in and manage your affairs. The problem with the conditional power of attorney is the fact that it is conditional. And if someone needs to use it quickly, if your spouse or partner needs to use this power of attorney quickly because you're not able to act on your behalf, they're going to be running to your doctor trying to get something from your doctor stating that you're incapacitated. And that's not always something that you can get quickly. Okay, next slide, please. This next document I referenced before, I said it was a way of avoiding probate. A revocable trust is a document that kind of comes somewhere between a power of attorney and a will, okay? A revocable trust is it's a trust, which is, well, a revocable trust is a trust that allows an individual to manage your assets in the event of your incapacity, and it also provides for the disposition of property upon death. So first of all, let's start by defining what a trust is. A trust is an agreement between one party, often referred to as the grantor, the person making the trust, and another party, the trustee, for the management of property for the benefit of a third party. So it's kind of like a triangle. You've got the grantor, the person making the trust, you've got the trustee, the person managing the property, and then you've got the beneficiary, the person for whom the trust is established. Generally, when you create a revocable trust, you are the grantor, you are the trustee, and you're the beneficiary during your lifetime. So it's a little bit of a fiction. If I create a revocable trust for myself, I say, I've got this property, I've got this bank account, I've got this real estate, and I declare that I'm holding it in trust. I'm the trustee and I'm holding it in trust for myself during my lifetime. And oh, by the way, the trust is revocable and amendable and changeable. So at any time I can amend the trust, I can revoke the trust, I can recover the property. So it is a little bit of a fiction, but the nice thing about a revocable trust is that any assets that I title in the name of the revocable trust at the time of my death, that are in the trust at the time of my death, don't go through probate. So let's say I'm single and I have a house and I have a bank account, and but I do have a minor child and I don't want assets to go through probate. I can title my house, I can create a revocable trust, title my house in the name of the trust, put my bank account in the name of the trust, make my bank life insurance payable to the trust. And then if I become incapacitated, I name my child's godparent to serve as the trustee to manage the trust on my behalf and on behalf of my minor child. If I die, the godparent is still named as the trustee to manage all the assets that are held in the trust for the benefit of my minor child. So it's a revocable trust is a great way of avoiding probate. It's a way of planning for incapacity. It's very useful if you have, for example, an older parent who's a widow or a widower, and they're perfectly able to manage their affairs on their own, but you're worried that one day they won't. If they have a revocable trust, they can serve as trustee of their revocable trust so long as they like, but then they can name someone else to step in and manage the trust assets when mom or dad no longer feels up to it. And then when they pass away, the assets in the trust get distributed. So revocable trust kind of spans the area between a will and power of attorney. Okay, next slide, please. Well, I've already covered some of this, so we'll go on to the next slide. So we talked about probate. I said a revocable trust was a great way of avoiding probate. And you have to understand certain assets go through probate at death and other assets do not. And what determines whether an asset will go through probate? Whether or not you have a will makes no difference as to whether an asset will go through probate. You can have assets go through probate with a will and assets go through probate without a will. But it's only certain type of assets that go through probate. The assets that go through probate are separately owned assets, assets that are in your individual name. So if I have a bank account and it's in my name alone, that's a probate asset. If I die with the will, that asset will go through probate and it'll get distributed in accordance with the terms of my will. If I own that bank account and it's a probate asset and I die without a will, it will still go through probate, but it will instead get distributed in accordance with state law, because state law says what happens to the assets of a decedent if they die without a will. So separately owned assets are probate assets. But if it's a separately owned asset that has a beneficiary designation, like an IRA or an insurance policy, that's not going to go through probate. Assets that have beneficiary designations get distributed in accordance with the beneficiary designation. Be very careful, however. If you've made a life insurance policy payable to my estate, that will go through probate. So as long as you got an individual named as the beneficiary of a life insurance policy, it won't go through probate. If it's payable to my estate, it will go through probate. If it's payable to a minor, you're still going to have court involvement because the minor doesn't have the legal capacity to receive the property. So only separately owned assets, assets that don't have a beneficiary designation, go through probate. Also, tenants in common property. Tenants in common is a way of owning real estate, and the property is titled as tenants in common. A lot of married couples own property as tenants by the entirety with right of survivorship. It's possible to own property as joint tenants with right of survivorship. So two siblings can own property as joint tenants with right of survivorship. Two unmarried partners can own property as joint tenants with right of survivorship. The deed says that if one passes away, the property automatically passes to the survivor. That real estate will not go through probate. But if I'm a tenant in common in real estate, I and my three siblings each own a 1/4 interest in a piece of real estate as tenants in common. And at my death, I'm free to leave my quarter interest to my kids. That 1/4 interest will go through probate. So you have to, as part of your estate planning, you need to sit down and you need to look at, okay, what are my assets? How are they titled? And how are they going to pass in the event of death? And if you have assets that are probate assets, then you may want to consider setting up a revocable trust in order to avoid probate. Could we go to the next slide, please? So what is probate? We've been talking about probate and assets going through probate. Probate is a court-supervised process for gathering and distributing a decedent's assets after the payment of liabilities, expenses of administration, taxes. When someone dies, there's a whole lot of stuff that needs to be done. Someone's got to pay funeral bills. Someone's got to pay the decedent's credit card bills. There are going to be medical bills coming in. All of that stuff has to be taken care of. In addition, someone may have to file the decedent's, if the decedent was filing income tax returns, they have to file the decedent's last income tax return. There may be an estate return due, an estate tax return due, either for, and estate taxes are like inheritance taxes, either at the federal level or at the state level. So once all of that's done, then assets can be distributed to the designated beneficiaries, to the people that are named in the will or to the people that are named in the revocable trust. The probate process starts by putting the decedent's will on record with the court where the decedent is domiciled. So if I'm a resident of Montgomery County, my estate's going to be probated in Montgomery County. If I'm a resident of Fairfax, it'll be Fairfax. But someone has to take the will down to the courthouse and say, look, here's the decedent's last will and testament. I'm named to serve as the executor in this will, and I'm asking you, the court, to give me that authority. Once someone is named as executor, then there are certain steps that have to be followed. See the next slide, please. So assets passing through probate are referred to as a decedent's probate estate. Okay. Probate estate is a subset of the decedent's total estate for estate tax purposes. So it's possible that I have only one asset going through probate, but I've got all these other assets out there that are passing by beneficiary designation, by like the pension plan, life insurance, by right of survivorship. Those are all referred to as the estate, but the probate estate are just the assets that go to probate. And those are the assets that the executor or the personal representative is responsible for administering and then distributing in accordance with the terms of the decedent's will. And the executor has, like I said, certain procedures that they have to follow, and those procedures vary depending on the jurisdiction in which the estate is being administered. Maryland has different procedures than Virginia, and Virginia has different procedures, and they both have different procedures than DC. Oftentimes, the executor needs to obtain a separate taxpayer ID number for the probate estate. They will have to file a separate fiduciary tax return for the estate to report income that's earned during the period of administration. Let's say someone dies in August and they have this huge bank account and a brokerage account, and it's May of the following year before everything's done and I can distribute the assets out. Well, that brokerage account and that bank account has been earning interest and dividends and all of that. So someone's going to have to file an income tax return for the probate estate, for the estate, before you can close it out. Once everything is done, once all the taxes are paid, the debts and expenses are paid, and expenses of administration, then the personal representative or the executor can distribute out the assets to the individuals named in the will. Next, please. So it sounds like a process, and it is, and it can be time consuming. So why would anyone want to go through the process? Well, there are certain advantages to probate, and it's something that needs to be considered. If you're worried that the estate may not be administered properly, if you're worried about, if there's perhaps a lot of fighting within the family or people don't get along well, then having an estate go through probate means that the court is supervising the administration of the estate, and you can be guaranteed that everyone is going to get what they're entitled to get, and the debts will be paid and everything will be taken care of. Going through probate usually sets a limit on the amount of time someone has to challenge the will. It establishes limits on the time creditors have to make claims against the estate. For example, in DC, when you probate an estate, notice is published in the newspaper saying that so-and-so has been appointed the estate of John Doe, and creditors have until such date to bring claims against the estate. If they don't bring claims within that 6-month period, then those claims are barred. So you know that someone can't come back and say, hey, you know, your dad owed me all this money and it was never paid to me. It's a cutoff. And again, like I said, if there are disputes among the beneficiaries, the court can settle those disputes. Next. So now we're going to talk about the disadvantages of probate, and I've already alluded to them. Probate can be lengthy. It can take time. There are certain things that you've got to do. You may have to file notice in a couple of newspapers, provide notice to interested parties. You may have to file inventories and accountings with the court. And that can take time. I know with COVID and everything else, the courts are running remotely. It is taking ages to get accountings approved in the District of Columbia. So it can extend the period of time through which an estate is under administration. Costs associated with probating an estate can be expensive. You might have you have to take into account court fees, attorney's fees, executor's fees. There may be fees for preparing an accounting, fees that you pay when you file an accounting. Also, lack of privacy. Once a will goes on record with the court, it becomes a matter of public record. So if you're worried about nosy neighbors or someone, you know, wanting to see what's happening with your estate, they could go down to the courthouse and get a copy of the will. Okay, next, please. So, you've seen the advantages, you've seen the disadvantages. How do you avoid probate? Well, we've already sort of talked about that. You can put property in joint names, okay? That's one way of doing it. I have, my mother's elderly, she's got a bank account, I'm her sole heir. I'm the one that's paying all of her bills. I'm gonna be entitled to the property anyway. She could put me on the bank account if she wanted to. So it'd be a joint bank account. And if anything happened to her, that bank account automatically becomes mine. It doesn't go through probate. Possible gift tax consequences to doing that. With a bank account, if during my mom's lifetime, I take money out of that account for myself, not for my mom. I pay her bills, and then I decide I'm going to write myself a check on that account because, I need some cash, and mom's okay with it. But if I take money out of that account, that's a taxable gift, or it could be a taxable gift, and a gift tax return may need to be filed. So putting property in joint names could have gift tax consequences. That's especially true if you have real estate, because if you put, let's say, a child's name on a deed to real estate, you've in effect made a gift to them of a portion of the real estate. And again, there's some nuances there, but it's something that you need to be aware. Also, putting property in joint names is not really appropriate for minors. If your children are minors, you don't want to put them on the deed to a piece of real estate, because if the time comes to sell the real estate, the children don't have the legal capacity to sign the deed. And you couldn't necessarily sign on their behalf because there's a conflict of interest there potentially. So you don't want to put minor children on deeds to real estate. Designating a beneficiary is another way of avoiding probate. Like I said, with life insurance pension plans, you designate an individual as a beneficiary, it's going to get paid to that individual, but again, not appropriate for minors. A revocable trust is a great way to avoid probate, because if you put all of your probate assets into the revocable trust, then if they're in the trust at the time of your death, they're not going to go through probate. And a revocable trust is great if you have minor beneficiaries, because remember, with a revocable trust, so long as you're alive, you're the trustee, you control that trust. It's an alter ego for you. You can put assets in the trust, you can take assets out of the trust. The trust is ignored for tax purposes, but if you pass away, the person that you've designated as a successor trustee can step in and manage the assets. And if you have minor children who are the beneficiaries of that revocable trust, then the trustee will be managing the trust on behalf of the minor children until they reach the age of 18 or 25 or 30 or whatever age you specify in the trust document. So it's a seamless way of providing for children. And with a revocable trust, you could, for example, I said you never want to designate your estate as the beneficiary of a life insurance policy, but you can designate a revocable trust as the beneficiary of a life insurance policy. And it will not go through probate because the trust exists prior to death. So if I pass away and my insurance is designated to my revocable trust, the successor trustee, the person I've designated as my successor, would then receive the insurance proceeds and would have immediate access to those funds to provide for my minor children. Okay, next, please. So what are the advantages of estate planning? And I want to make sure I leave enough time to talk about estate taxes. So what are the advantages of estate planning? Well, first of all, protecting yourself, your family, and your assets in the event you become temporarily or permanently incapacitated. The powers of attorney are very important for the latter. A medical power of attorney, a healthcare power of attorney, a financial power of attorney. If you're incapacitated, whether it's permanently or temporarily, you know that someone else can do the stuff that needs to be done. Pay your bills, pay your mortgage, open and close bank accounts, whatever needs to be done. Estate planning also provides for the orderly disposition of your assets in the event of death, and it appoints the appropriate persons to manage your affairs. Like I said before, if you die without a will, it's state law that governs who will receive your assets, your probate assets, because assets that are jointly owned with right of survivorship will automatically pass to the joint owner. Assets that have a beneficiary designation will automatically pass to the designated beneficiary. But all of us have some probate asset. I mean, if you probably go down the list, you'll find at least one asset that's a probate asset. It might only be your car, but it's still a probate asset, and you're still going to have to deal with probate. So it helps to have a will, because then it's clear where everything is going. And you can name the appropriate people to serve as the executor of your estate. If you have minor children, extremely important. You need a will. You've got to name a guardian for those minor children. If something happens to you and your spouse or the other parent, you need to name a guardian. And also establish trusts for minor beneficiaries. Finally, and this is the next segment we're going to be turning to, is planning to minimize federal and state estate taxes. Okay, and A lot of people, when I say estate taxes, they think I'm saying state taxes, like a state income tax, like Maryland income tax. Here we are talking about inheritance taxes, taxes that are due at the time of death by reason of your death. Okay, so we're going to be taking some questions at the end. So I'll try and I'm sure some of you may have some questions on the segment that we just finished, but let's talk first about the estate and gift taxes, and then I'll take some questions at the end. Okay, next. Okay, so estate taxes, federal and state. Let's start with the federal. The US imposes an estate tax for the transfers of property at death, okay? And there is a corresponding gift tax for transfers of property during lifetime. In addition, many states impose their own estate tax in addition to the federal tax. That number has come down significantly. I would probably say it's less than half of the states, maybe it's a third of the states that now have an estate tax of their own. But in those states that do, it's something that you need to be concerned about. And it's important to recognize that estate and gift taxes affect not only US citizens and residents, but non-residents as well. G4 visa holders are not exempt from estate taxes. That's very important. I want to stress that because a lot of you are, G4, you're exempt from paying income tax. You only pay tax perhaps on your US source income, rental income, things like that, but your compensation is not taxed. You're not taxable for income tax purposes. But for estate tax purposes, the fact that you're a G4 visa holder does not prevent you from being subject to estate tax. And it may actually cause you to be taxed in a manner that's worse than if you were a citizen or a resident. Okay, next, please. So let's start first with state estate taxes. Okay, just a very brief summary. Maryland and DC impose estate taxes in addition to the federal estate tax. The Maryland estate tax exemption is currently $5 million. It's a flat $5 million. And each spouse is entitled to, each individual is entitled to a $5 million exemption from estate tax. So what that means is if your assets at the time of death are worth less than $5 million, then there is no Maryland estate tax due. If you are a husband and wife of a married couple, each spouse has a $5 million exemption. And if one spouse passes away, that spouse's exemption amount can be passed on to the surviving spouse. So that in effect gives the survivor $10 million if they could pass away free of estate tax. DC's estate tax exemption is currently $4 million. Up until December 31st, it was something like $5.72 million. Last year, DC reduced its estate tax exemption amount to $4 million because of COVID and the budget crisis that they're facing. They've lost a lot of revenue. So DC reduced its estate tax exemption to $4 million. They will start indexing it annually for inflation beginning next year. Still, it's a $4 million exemption, and there is no portability in DC. The top marginal rate for the estate tax in DC and Maryland is 16%. Now, you don't get to that 16% rate until your estate goes over $10 million. So, between 5 and 10 million, your effective rates are probably somewhere between 12 and 16%. Okay, still not a huge. It's not a huge tax, but it can be. It can be a significant tax. I mean, if you're talking between 12 and 15%, if your estate is in excess of those exemption amounts. If you live in Virginia, you're lucky. Virginia has no estate tax. Okay, next. I also want to highlight that in addition to the estate tax, Maryland also imposes an inheritance tax. This tax, the tax rate is determined by the degree of relationship to the decedent. So there are so many exemptions. If you're a spouse, if you're a child, if you're a grandchild, if you're a sibling, if you are the spouse of a child, the tax rate is 0. So in effect, there is no inheritance tax if the property is left to someone who is closely related to the decedent. But if you are single, you don't have kids, you're leaving your property to your best friend or to perhaps your boyfriend or girlfriend or to someone that you're not married to, then you need to contend, you need to be worried about the inheritance tax. And the rate on taxable transfers, if there is a tax due, is 10%. Next slide, please. So we've talked a little bit about the DC and Maryland estate taxes. We said Virginia has no estate tax. What is the federal estate tax? Because that's really the most significant of the taxes. If you are, it's a tax on the value of property owned at death by the decedent. So if you are a citizen or resident of the US, then you are subject to estate tax on the fair market value of your worldwide assets, okay? Subject to certain deductions and credits. Okay. So if I've got $10 million worth of assets, and what does that 10 million include? It includes real estate, it includes bank accounts, it includes life insurance, it includes the present value of the surviving spouse's pension, it includes my IRAs, it includes my jewelry, my cars, my foreign real estate, my foreign bank accounts. If you are a citizen or resident of the US, it's your worldwide assets that are subject to estate tax. If you are a non-resident, you are only subject to estate tax on the fair market value of the assets that are situated or deemed to be situated in the US, which is primarily real estate. And if you have US stocks, US mutual funds, your tangible property that's located here, your cars, your jewelry, that is your US estate. As we'll see in a minute, however, it may not be a good idea. You may be worse off if you're considered non-resident. An individual who has a G4 visa may be considered resident for estate tax purposes, okay? That's different than it is for income tax purposes. For income tax purposes, you have a G4 visa, you're considered to be non-resident. It's a bright line test. For estate tax purposes, you are a resident if you are domiciled here. Can we have the next slide, please? So who's a resident for purposes of the estate tax? Permanent resident. If you're a permanent resident of the U.S., you've got a green card. You are resident for estate tax purposes. If you are a G4 visa holder who has a domicile in the U.S., you are considered to be resident for purposes of the estate tax. And how do you establish a domicile? You establish a domicile by being physically present in the U.S. and having no current intention of leaving. Your intent is determined by all the facts and circumstances. And once you establish a domicile, it's usually retained unless steps are taken to abandon it. So you've got to look at things like, where's your primary residence located? What's the status of your other family members? Where are most of your assets located? How long have you been in this country? Are you intending to stay here? If you are eligible to apply for a green card and you're planning to do that when you retire, then you are a resident for purposes of the estate tax. Because you have the intent to remain in the US, you've established the intent to remain here and you're physically present. Okay, that you may retain that status as a domiciliary of the US if you're gone temporarily. So you've been here for 20 years, but you're getting ready to go on a mission for the next 2 years. You're going to be outside of the country, but you're planning on coming back. If you've established a domicile here in the US, you probably will still retain that domicile unless you take steps to establish a new domicile in the country where you are posted. Okay, next. So we said that if you're a citizen or a resident, your gross estate consists of your worldwide assets, all of your real estate, both US and foreign, your bank and brokerage accounts, wherever they're located, your life insurance, pension and retirement plans, tangible personal property, jewelry, it's everything. Next. If you're a non-resident, your gross estate only consists of your US assets. And I said that's US real estate, US stocks, brokerage accounts, money market accounts, tangible property that's located in the US, stocks, mutual funds, things like that. Your gross estate, however, does not include foreign real estate. It doesn't include bank pensions, checkings and savings accounts, certificates of deposit, life insurance, or foreign stock or assets that are located abroad. Now, you may be saying, well, it sounds like I want to be a non-resident for purposes of the estate tax, but that's not necessarily the case. Next. Here are the tax rates, just a quick historical. 2013 to the present, we're at 40%. So you can see it's a significant tax. Next. The estate tax is calculated when you start off with the gross value of the decedent's estate. Then I said you take certain deductions for debts, expenses of administration, state taxes, and if available, marital and charitable deductions. You calculate the tax and you apply the estate tax exemption amount. The estate tax exemption amount is what determines how much tax you're going to pay in the final run, how much of your estate is exempt from estate tax. Next. Every citizen or resident of the US and a G4 who is considered resident, domiciled in the US, gets to exempt the first $11.7 million of their assets from estate gift taxes. It's a huge exemption amount. If you are a G4 who is non-resident, you only get to exclude $60,000. While that 11.7 has been increased many times over the last 20 years, that 60,000 I don't think has changed since 1981. You do not want to be considered a non-resident, a G4 who is non-resident in the US, if you own real estate in the US, because you're going to end up paying estate tax. And really, there are a lot of G4 visa holders who do own real estate. They have a house, and if you're planning on retiring and moving back to your home country, you want to make sure that you dispose of that real estate before you go, or you make other arrangements to pay any estate tax that will come due. Because if I'm a G4 non-resident in the US and I have a house that's worth 600,000 and I can only exempt 60,000 from taxation, and my top marginal rate is 40%, you can see that that's going to be a significant tax. So it's better off to be considered, if you have real estate in the US, if you're planning to stay in the US, to get this very, very large exemption. It's indexed for inflation. It started off, it's 10 million indexed for inflation. About 3 years ago, when they passed this tax legislation, they doubled the exemption amount from 5 million indexed to inflation to 10 million indexed for inflation. And it's going to keep increasing every year until we get to the end of 2025. And under the current law, there's a sunset provision, which means that on January 1st, 2026, this 10 million indexed for inflation will go back to where it was. It'll be 5 million indexed for inflation. So at the end of 2025, the estate tax exemption amount might be 6 million or 6.2 million or whatever it is at that time. It will be cut in half. That also presupposes that there are no other changes made to the estate tax that Congress doesn't make any other changes prior to the end of 2025. Okay, in certain cases, my exemption of 11.7 million, if I pass away and leave everything to my husband can also elect to carry over my exemption amount. So a married couple in practice who are citizens or residents of the US can leave 23.4 million to their children free of estate taxes. Next. Okay, what I just referenced is, we're getting close to the end here, so I'm just going to try and get through some of this very quickly. I referenced carrying over my exemption amount, my husband carrying over my unused exemption amount. That's called portability. Prior to 2012, that was not available. So if I died and I hadn't used my exemption amount, it would have gone to waste. Congress decided that didn't make sense. So they now allow that carryover of the exemption amount. But in order to take advantage of that, you have to file an estate tax return, and you have to elect portability. And the deceased spouse's portability amount does not continue to increase for inflation. It's frozen wherever it was at the time of death. Next. Another very important deduction, I mentioned that once you get the gross estate, you take certain deductions. A very, very important deduction is something called the unlimited marital deduction. What that means is, regardless of the size of your estate, any property that's left to a US citizen spouse is free of estate tax. You get a deduction for it. If I'm Warren Buffett and I leave $1 billion to my spouse, my estate gets $1 billion deduction. Okay, there is no estate tax on property passing to a US citizen spouse. If the spouse is not a US citizen, if they're a green card holder, if they're a G4, you don't get this unlimited marital deduction unless the property is put into something called a qualified domestic trust. The estate tax exemption lately has been so large that very few people have had need of one of these qualified domestic trusts. If the estate tax exemption is reduced again, these qualified domestic trusts will become more important. Next. And a qualified domestic trust is a trust that is established that I can provide for in my will or in my revocable trust. It's a trust that's established after death. It's for the benefit of a non-citizen spouse. It must have a US citizen serving as trustee. The spouse can have all of the income that's generated by the trust assets, and no estate tax is paid on the assets in that trust unless principal is distributed for reasons other than hardship. It has to meet certain other statutory and regulatory requirements. Next, please. So, like I said, it can be established in a will, it can be established in a revocable trust, but if there is no provision made in a will or trust, it can also be established after death by a surviving spouse for his or her own benefit. You generally have about a 15-month window in order to do that. So if you have a large estate and you're worried about estate taxes, that might be something to consider if you're worried about your spouse having to pay estate tax. Next, please. Okay, so the exemption amount can be used to cover that $11.7 million exemption amount can be used to cover assets, the tax on assets passing to anyone, a non-citizen spouse, children, friends, whoever it is. If assets pass to a US citizen spouse, they qualify for the marital deduction, no estate tax. If the spouse is a non-citizen, then the only way to get assets tax-free to your spouse is either to use up your exemption amount or to establish the QDOT. Okay, next, please. A bypass trust, and a bypass trust is, I will just say this, it's a mechanism that can be used that prior to portability was used to take advantage of the exemption amount of the first spouse who passes away. We are still providing for bypass trusts in our estate planning documents because we're worried that portability may be eliminated, or if portability is not allowed, you might need a bypass trust, not for federal tax purposes. I mean, the federal exemption is 11.7 million, but the DC exemption is only 4. So you might not need a bypass trust for federal purposes, but you do for state purposes. Okay, next, please. Okay, I think this is just kind of a summation of where we are. I think there are probably some questions, and I wanted to leave at least a couple of minutes for questions. So I'll stop here.
Maria, thank you for that amazing information. So much to get through. So thank you. And you did an amazing job. And I do want to answer right now so that everybody knows. And there was a question on the chat. This information and this webinar has been recorded. We will be sending it out with the deck, with the presentation that Maria put together, as well as the recording. So please don't worry, you will get this information and you will be able to review it at your leisure. Additionally, I want to let you know before we get into the questions that we are going to be sending a survey link out now. I actually will send it out now to the chat. So it helps us adjust these presentations. It helps us add additional presentations going forward because we're continually adding them in 2021. So please take a moment to fill out that survey at your earliest convenience. And also we'll be sending you an email right after this. So I know we're a little bit short on time. We have 5 minutes. So I'm going to get through as many questions as possible. Maria, I own a house, but I'm the only one on the mortgage. I have put my husband on the deed. If I die, will he have to pay gift taxes, or does this apply only if the house has already been paid for?
Well, that's complicated. If your husband's on the deed, you put him on the deed when you purchase the house. Is your husband a US citizen? If he's a US citizen, you've got nothing to worry about. You don't need to worry about gift taxes. You don't need to worry about estate taxes because the property will pass to your husband by right of survivorship and there won't be any estate tax due. If your husband's not a US citizen and you're the one that's been paying for the mortgage, there's a presumption that if the surviving spouse is not a US citizen, when they inherit property by right of survivorship, that 100% of the value of the property is included in your estate, unless your husband can prove contribution. So if your husband's not on the mortgage, but you've been paying for the mortgage out of a joint checking account, you've both been putting your salaries into the joint checking account, your husband would be able to prove contribution. And it might be that only half of the property is includable in your estate and the other half is deemed to belong to your husband. It depends on the facts, so.
Thank you, Maria. So there was a lot of things at the beginning of the presentation where you talked about last will and testament. I can't even say that word, revocable trust, living will. How long does it take approximately to complete each one of those processes, and how much approximately does it cost?
Right. Attorneys charge differently. Some attorneys will charge a flat fee for a package. Some attorneys will charge on an hourly basis. I personally charge on an hourly basis. A typical estate plan for a husband and wife, with wills for each of them, a revocable trust for each of them, powers of attorney, medical powers of attorney, all of that. I mean, you could probably expect to spend anywhere from $2,000 to $3,000 on average. It could be less. If your case is really simple, you don't need a revocable trust, you don't have minor children, you don't need to worry about trusts. It could be more if your assets are complicated. So it's really hard to say. But I would just make a couple of calls to different attorneys, talk to them, see how they bill. And again, it depends on your particular situation, because not every will is the same, not every revocable trust is the same.
Perfect. So I'm going to go through 2 more questions because I
Okay.
know we're coming towards the end. Regarding estate taxes, what if you live abroad and your beneficiary lives abroad, both US dual citizens?
If you are both US citizens, that's the joys of being a US citizen. You are subject to estate tax and income tax regardless of where you live. So if you are a US citizen that lives abroad, you are subject to US estate taxes. If your beneficiary also lives abroad, that's fine. It doesn't matter. The status of your beneficiary is irrelevant for purposes of the estate tax, unless we're talking about a spouse, in which case it makes a huge difference because a US citizen spouse gets the unlimited marital deduction. But if the beneficiaries are children or siblings or other family members, it makes no difference whether they're US or non-US. The tax is imposed based on the status of the decedent. And as a US citizen, you are subject to estate tax on your worldwide assets. You get that $11.7 million estate tax exemption.
Okay, last question for the day. Is there any tax involved in the retitling of a real estate to my adult child?
Um, Retitling of real estate to an adult child. Well, if you make a gift of the property, there is a gift tax that's due, and you have to file a gift tax return. Gift tax returns, you can make gifts of up to $15,000 a year to any beneficiary without incurring gift tax liability. But if you give your child more than $15,000 in a year, that gift tax return has to be filed by April 15 of the following year. It's a Form 709. You report the value of the gift that you've made. If you're a US citizen or resident, what happens for practical purposes is you don't pay gift tax, but you don't pay out of pocket, but you reduce your exemption amount. So if the real estate is worth $400,000, your exemption amount will go from 11.7 to 11.3. So you have to show the reduction in your estate tax exemption.
Amazing stuff, Maria. You have a lot of information in their head. I want to thank everybody for coming. Again, please go to our website, idbglobalfcu.org, to take a look at the webinars we have coming out. We will be sending this webinar out to each one of you as well with the presentation. So I'd like to give a warm thank you to Maria for everything that you provided to our attendees today. And to our attendees, thank you for being with us. Have a wonderful day, everybody.
My pleasure. Have a good day.
Bye.
Bye.